Good day, Crime Talk aficionados. It is officially the weekend. And guess what? We have all the top stories throughout the week located in one convenient location for you. We hope that you enjoy it. Thanks for watching, and we'll see you next time on Crime Talk.
Hi, lawyer.
First, Richard Allen. That's right, the Delphi case. So the prosecuting attorney handling this case is a guy by the name of Nicholas McClellan. And he responded to Richard Allen's defense team by saying that a pair of interviews conducted in the early days after the Delphi murders, which were accidentally recorded over at the police station, were not evidence at all related to this particular case. So a few weeks ago, as you may recall, Richard Allen's attorneys filed a motion to dismiss the murder charges against their client on the grounds of the destruction of this evidence. Probably not going to carry the day, but it certainly makes the police not look competent. Anyway, as you may recall, Mr. Allen is charged with 2 counts of murder as it relates to the deaths of Libby German and Abby Williams near the Monon High Bridge near Delphi, Indiana, back in February of 2017. So Allen's attorneys claimed in early February that the police interviews conducted with 2 men in the days following the discovery of the teenage girls' bodies were significant to their alternate theory that the girls' deaths were part of the ritualistic killing that ties to Odinism. However, it's alleged that the raw footage of these interviews doesn't exist. Only some documents summarizing the interviews with the 2 men who the attorneys, Rozzi and Baldwin, call key suspects. Now, McClellan confirms that these interviews were in fact destroyed inadvertently, accidentally. So we just fat-fingered and hit that delete button. It happens all the time, and I'll explain more. And so, according to the prosecutor, a DVR error caused the device to continually record for an unknown number of days, recording over all the existing footage already on that particular device. All the interviews conducted in the Delphi Police Investigation Room prior to February 20th, 2017 were lost due to this error, the district attorney reports. Therefore, it's all okay. They were not destroyed by the state purposely or in bad faith, Mr. McClellan writes in his response. And while recordings of the raw interviews no longer exist, it shouldn't be a problem because the attempt to have the charges thrown out because of this destroyed evidence are not even really evidence related to this case. The evidence in question is not exculpatory, which means it helps the defendant. Otherwise, it would be inculpatory. It inculpates them for liability as to the crime. And they say that it is potentially, not even potentially useful evidence. Now, the prosecutor stated that the interviews with the 2 men instead is just the defense's team attempt to prop up their wild theory of their case and has no evidentiary support whatsoever. Now, the theory is in question is Rozzi and Baldwin, the attorneys, previously claimed that Allen wasn't responsible for the death of these 2 young girls and best friends who went for a walk on this historic Delphi trail only to be killed. Now, Mr. Rozzi and Baldwin instead have presented a conspiracy theory of a ritualistic murder seeped in the occult. But this theory has been shot down by McClellan before as being unfounded and with absolutely no proof. Now, while footage of these interviews no longer exists, they're summarized, and guess what? The defense can go and interview these guys, so what's the big deal? Now, the defense is obviously saying, hey, we don't know exactly what was in those interviews because this could aid in our defense, but they've destroyed the evidence. And, of course, the prosecutor says, well, that's just mere speculation. But how do you know what you don't know? Because you weren't there and it wasn't recorded. Let me just tell you, generally, ladies and gentlemen, a video interview can be done. It can be 5 hours long. It'll be summarized. And I swear you have to go through everything. And thank God there's good technology now. You can upload it all and get a pretty good transcript of documents these days. But the detectives never summarize it fully and completely. And in their summary, they usually leave out all the good stuff for the defendant, just based upon my years of experience. ladies and gentlemen. And so that's why the defense is obviously a little skeptical of the state's claim. Now, let's talk about this really quick, okay? I'm really starting to dislike this prosecutor in the Delphi case quite a bit. I don't like how he says, oh, the defense theory is completely irrational and dismissive. It's kind of like what the district attorney said in arguments a couple of weeks ago, where it said the defense attorney, moi, wasn't sure if it was my complete misunderstanding or ignorance of the law. Let me state this. I'm getting more and more tired of the district attorney in the Delphi case, Mr. McClellan. His repeated attacks against the prosecutors, it's just weird and it's personal, okay? And I've had cases like this. I had a case just 2 weeks ago where I was in court. We're making an argument. We got a trial coming up. And the prosecuting attorney comes out and says some bizarre stuff that, well, this must be the defense counsel's complete ignorance of the law. I look over like, okay, really? And the judge kind of looks at her as well. Like, that's not very professional conduct, but, whatever. And of course I get up and I say, I think their position was I was completely ignorant of the law, but I've been right. Okay, I've been right, and that's why every judge has reversed their previous opinions in this particular case, right? So when the prosecutors start throwing jabs personally at the prosecutor, then that is a problem for the prosecution. It shows that they have troubles and they don't like what the defense is saying. Just my opinion. Take it for whatever it's worth. Now, do I think that this issue will be resolved in the favor of Richard Allen? No, because Judge Francis C. Gull denies everything that the defense asked for in this particular case. And it really comes back to a federal case, United States Supreme Court case, as it relates to the destruction of evidence. I know you may say, oh my gosh, this is such a unique thing. No, this kind of stuff happens quite routinely. And frankly, a case that I was just talking about, what a coincidence. All the exculpatory interviews just happen to be accidentally erased. Swear to God, happens all the time. But don't worry, we got a summary. Don't worry about it. I don't want the summary. I want the video that they destroyed. And of course, there's no sanction because, well, they testified that it was not a problem and it was unintentional and it was just an accident. So therefore, no bad faith. Okay, so where does this come from? The law. It's in regards to a case, California v. Trombetta. And it stands for the general proposition that the state's duty to preserve evidence obtained by law enforcement officers during the investigatory stage of a case of an accused use at trial in defense of a criminal charge. Like I said, that's California Trombetta. The Supreme Court in that case considered the scope of that duty under the Due Process Clause of the 14th Amendment and determined that it must be limited to evidence that might be expected to play a significant role in the suspect's defense. And to satisfy that test, the constitutionality materiality, as it relates to the evidence, must both possess an exculpatory value that was apparent before the evidence was destroyed and be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means, right? So that's why the defense is going to lose. Prosecution's already said, it was insignificant, no big deal. Sure, it may go directly to the defense's theory, but we don't think it's relevant. And then, it was really just an accident, no bad faith. So these Trombetta motions, and usually the states have a similar case for the same proposition because it happens all the time. Okay, it really does. Prosecutors mess this stuff. Police officers mess this stuff up all the time. And it's always the good stuff. I don't know what it is. The good stuff for the defense that gets erased accidentally all the time. It's crazy. But that's okay. The prosecution always gets their way, and that's just the way it is. So deal with it, everybody. It's not due process issues. Don't worry about it. All right, next on the docket, Alec Baldwin. He's also getting a trial date. A New Mexico judge has set a trial date for Alec Baldwin on the involuntary manslaughter charges stemming from the deadly shooting back in 2021 on the movie set Rust. The scheduling order calls for jury selection to begin on July 9th, with the trial starting the following day with opening statements by the special prosecutor and Baldwin's defense attorneys if they choose to do one. Remember, the defense never has to say anything. Now, the trial is expected to last in Mr. Baldwin's case for about 8 days. And according to the order, all motions and final witness lists must be submitted by May 6th, which is about 2 months after the state has submitted their initial witness list that has about 32 names on it, including the film's armorer, Hannah Gutierrez, and we are live streaming her trial with you right now. You should check it out. And you should also see why they're talking about the gun and why, well, it just couldn't have gone off, which has been Alec Baldwin's defense and his statements all along. What have we said, ladies and gentlemen? It's always the defendant's own words that come back and bite them in the end. And I think his own words will come back and bite Mr. Baldwin. Now, obviously, if things don't go well for the prosecutors in the Hannah Gutierrez case, things will go well for Mr. Baldwin. However, if things go poorly for Hannah Gutierrez, they're probably going to go very poorly for Mr. Baldwin as well. Hannah Gutierrez's defense team is pointing the finger at Alec Baldwin. Alec Baldwin is going to point the finger at Hannah Gutierrez. It's going to get interesting. Now, as you may recall, Baldwin's team filed for a request for a speedy trial to minimize his public vilification and suspicion and to avoid the hazards of proving innocence that often arises after a lengthy delay in the prosecution. Now, obviously, the defendant never has to prove his innocence. That burden always remains with the prosecution to prove their case as to each and every element of the offense charged beyond a reasonable doubt, unanimously to a jury of 12 people. So, Mr. Baldwin should know better that he does not have to prove his innocence. Now, as I noted, Baldwin has said that he pulled back the hammer, but not the trigger, and then the gun fired. Now, the subsequent analysis concluded that the trigger had to be pulled or depressed sufficiently to release the fully cocked or retracted hammer on the revolver that was involved in the incident. The revolver is also a subject of the testimony in the case of Hannah Gutierrez, which we've been bringing you today. Today's good stuff, and it shows the functioning of this particular revolver. So just like Hannah Gutierrez, Alec Baldwin faces up to 18 months in prison if he is convicted. Next, let's talk about the Georgia case regarding Lakan Riley. So the neighbors of the young Venezuelan migrant accused of killing Lakan Riley claims that he would watch the young lady on the running path all day long, and that he was seen on security cameras throwing out bloody clothes on the day of the attack. Now, Jose Antonio Ibarra was arrested at his apartment complex near the running trail, close to where Riley's body was found last week. Now, residents of the complex have told reporters that their security cameras captured Ibarra disposing of evidence in the building's dumpster, which they turned over to the police. He apparently took a lot of the evidence. He's on camera with his bloody clothes in a bag, the one neighbor noted. The neighbor also added that she had seen Miss Riley cut through the complex previous occasions to get to the running path, and claimed that Ibarra has likely seen the student because he would sit outside all day. The neighbor said that he was out there all hours of the night and day just looking around. Now, the complex is a former hotel converted into studio apartments, and it is believed that Mr. Ibarra is said to have lived in one unit with 4 or 5 other men. Now, the 26-year-old has been charged, obviously, with the killing of Miss Riley with felony murder charges, false imprisonment, kidnapping, and concealing the death of another. Now, Mr. Ibarra is accused of using an unknown object as a weapon to kill the nursing student, as well as preventing her from making a 911 call when he allegedly grabbed her sometime between the hours of 9 a.m. and 1 p.m. on Thursday, February 22nd. Now, Miss Riley's body was found the same day on the University of Georgia campus in a wooded area near Lake Herrick that includes trails popular with runners and walkers. Miss Riley had been out jogging when she was allegedly attacked by Mr. Ibarra. Now, the police have said that Miss Riley died from blunt force trauma after being beaten and that she suffered a disfigured skull. They added that Ibarra dragged her body to a secluded area to conceal her death. This is according to the arrest affidavit. And the police said that Ibarra, who lives in Athens, apparently did not know Riley, and they believe that he acted alone. Now, video from the campus security and other technology led the police to Mr. Ibarra. Now, the day of the murder, her suspected killer unloaded a selfie on his TikTok account in which he stared into the camera and grinned. 5 months before Riley's murder, Mr. Ibarra had been arrested in New York and charged with acting in a manner to injure a child less than 17 and a motor vehicle license violation. Now, he was ultimately reported to ICE, but the NYPD released him before ICE could get to him, before the detainer could be issued, and therefore he was released. We also know that Mr. Ibarra crossed the El Paso, Texas border back in September of 2022, but was also released from that detention center due to a lack of space. We'll just have to wait and see how this one plays out, ladies and gentlemen. Doesn't look good for Mr. Ibarra. Obviously, he gets the presumption of innocence like anyone accused of a crime does, but it doesn't look good. No word exactly whether he confessed to the police or whether he remained silent, but it sounds like there's enough video evidence that it really doesn't matter. Bryan Coburger. Now, they appeared in court yesterday, and the judge did not set a date for him to have a trial date start as of right now, as it relates to the death of the 4 college students. Now, at the hearing, the defense and prosecution discussed several issues with the judge, including the anticipated trial date. Now, the judge, John Judge, had previously indicated his desire to get this trial going sooner rather than later, and he was thinking maybe sometime this year. But the attorney said simply they could not be ready by the prosecution's proposed trial date of March 3rd of 2025. Ladies and gentlemen, that's a year from now. So the prosecution, as you may recall, had previously requested the trial to be held in the summer of 2025, but they apparently softened that position just a little bit and figured, hey, maybe we can do it while the spring break is going on. Now, Coburger's attorney said that the sheer volume of discovery and the difficulty that they've had in talking to witnesses means that they won't be ready until at least June of 2025. Well, the judge set another hearing date on May 14th on the defense motion to move the trial out of Latah County and bring in a bigger jury pool, kind of like we had in the Lori Vallow case and we have in the Chad Daybell case. Move it up to Ada County. Anyway, Coburger's attorneys say that the size of the community and the interconnectedness of its citizenry is problematic and will prevent a fair and impartial pool of jurors for Mr. Coburger. Now, the prosecutor reiterated his belief that we know there's publicity about this case. Everyone can agree there's massive publicity, but I see more about it in Boise, he says, than actual local news. So, like I said, it's not the question of whether somebody knows about it. It's whether they can put out of their mind what they've heard about it and make their decision only based upon the evidence in the case. Anyway, so Judge said that he would make a decision about the future trial date when he hears from both sides on May 14th. Now, do you remember when this case first got started? Bryan Coburger went to his hearing, and there was a trial date set. I think it was June of 2023. It was rather quick. Demanded a speedy trial. And then at the last minute, he blinked, and he said, fine, I'll waive speedy trial. And here we are now. Let's set the trial into the spring or summer of 2025. So basically, another year from now. Now, this is why, ladies and gentlemen, it is so important for a client to be completely truthful and honest when it comes to having a conversation with their attorney. Let's say hypothetically, I represented Brian Coburger, and I had a hypothetical conversation with him and said, listen, this is probably the most important conversation you're going to have in your life. Why don't you tell me exactly what happened? Don't leave out any of the details. And let's say hypothetically, he just lays it all out, and let's say hypothetically he admits that he's guilty. Hypothetically, because we give everybody the presumption of innocence, but this is the example. And let's say he tells the attorney, yeah, I did it all, okay? And all right, let's see. You look at all the voluminous stuff, all the scheduling. The prosecutor themselves now are currently saying they could not be ready until next spring or summer. Do you really think that they would have been ready to go in the June of 2023? No. Remember, the defense doesn't have to do anything. The prosecution has to do it. There's no way they would have got all those samples tested by then. There's no way they would be able to have all their witnesses ready. And guess what? He may have had a shot. Okay? But now, I've used this analogy before. All right? Think of the government as a huge steamroller. Okay? The kind that lays out all the asphalt after they, put the hot asphalt down. They go back and forth and it's steamy and stuff. They're a little slow to get going. But once they get rolling, you don't want to step in front of it. And so now when you give the government 3 years and a bunch of attorneys that are only working on this particular case, they are that steamroller, ladies and gentlemen. I don't think Brian Coburger is going to want to step in front of that very soon. He had his opportunity and he squandered it. Now, obviously, it's a little intimidating for an attorney to say, hey, I haven't seen all the discovery. Am I going to commit malpractice? Blah, blah, blah. But that's the kind of thing where you talk to the client, you fully advise them, say, hey, man, this may be our only shot. Are we going to go for it? Now, frankly, you need a client with quinones this big to do something like that. Most of them aren't willing to do that. I've only run across a few in my days of practice, but when they have gone along with that strategy, it has usually turned out well for them. So, quick lesson on strategy, quick lesson on why you tell your attorney everything when it really, really matters. And then you got to make tough decisions. A lot of nerves, a lot of little brinksmanship that takes place. But I think that Brian Coburger blew his opportunity. There's no way the prosecution would have been ready. And I said the same thing back on Lori Vallow and Chad Daybell. And had Lori Vallow gone to trial without the 10 months of competency, do you think the prosecution would have been ready? No way. Next on the docket. Yes, the Rust trial is providing us a little more insight as it relates to Alec Baldwin's conduct on the set. Now, we saw yesterday, and if you were watching CrimeTalk, you have seen the video already because we streamed the trial live from day one. Anyway, the video was played yesterday of Alec Baldwin using a gun as a pointing stick and opened fire after a director yelled "cut" on the set of Rust. Now, the movie, whose cinematographer, Alec Baldwin, accidentally shot and killed. Now, the footage broadcast in court showed the actor discharging a large prop weapon during the 2021 shoot, which was halted by the killing of Helena Hutchins. Baldwin was seen chatting to crew members and basically talking with his hands with the prop gun in one hand. In another scene shown to the jury, Baldwin was seen firing the gun a few seconds after the director had loudly yelled "cut." Someone could be heard exclaiming "mother effer" as he did so, although it's unclear why that was said. Now, it's alleged that the set was so unsafe that the actor pointed guns at a 12-year-old boy who was part of the cast as well. That came out in testimony. Jurors were shown a video shot during the production in which the adult male actor pointed the gun at Patrick Scott McDermott between scenes. Now, their safety expert says that was a breach of the safety rules, made all the more disturbing because 6 live rounds were found on the set. Now, the court also heard testimony from a senior crew member who said that Helena Hutchins, the cinematographer, said, quote, "I can't feel my legs after she was shot by Baldwin." Now, as you may recall, Baldwin is due to go to trial in July for involuntary manslaughter for the incident in Rust back in October of 2021 there in Santa Fe, New Mexico. He denies the allegations of wrongdoing and has even denied shooting Hutchins, although the gun was in his hand when the fatal shot took place. Now, the claims about safety came out during this trial of Hannah Gutierrez Reed, the armorer on the case. She has denied the same charge as Alec Baldwin, that being involuntary manslaughter, and like Mr. Baldwin, Hannah Gutierrez, the armorer, faces up to 18 months in prison if found guilty. One of the witnesses called to the stand was a guy by the name of Brian Carpenter. He's a former police officer who now works as an armorer and firearm instructor in both film and TV, and told the court about a litany of safety failings during the filming of Rust. The jury was shown footage shot behind the scene, which showed actors waving guns in the air. Mr. Carpenter said that they should have been pointed down, the guns, at all times when they were not being used for a scene. In quite a disturbing moment, he described the actor armed with a rifle, pointed it straight at McDermott, who was 12 years old at the time and played the character of Lucas Hollister. In another shot, the expert said the same actor pointed the gun at a man's back. Now, police later identified 6 live rounds on the set of Rust, including 2 in the gun belt of some of the actors. Mr. Carpenter said, "You have to assume there may have been live rounds in any of these firearms. Imagine the concern you have knowing at any point in time these guns could have a live round in it. That makes it more concerning when that shotgun is pointed at a man's back." Another video showed Gutierrez Reed holding a shotgun with its muzzle face up, pointing straight at her own face. When asked how you could maintain proper gun safety on a set when the armorer was handling guns in this way, Carpenter said, "It's a very good question. It would be hard to implement." Anyway, the video of Baldwin showed him emerging from a cabin and firing his pistol and then lying down on the floor, getting up and opening fire again. Carpenter said they were unsafe because camera by the cabin was well within the no-go zone and should have been 21 feet away. He criticized Baldwin and said he should not have pointed his gun right at the camera and should have cheated to the side by at least 4 feet. Now, the video of Baldwin on the floor shows him demanding a second shot immediately after one that just finished. You can hear Baldwin saying, right away, let's reload. Here we go, come on. We should have 2 guns both reloading." Asked if that is the kind of conduct was typical, their expert, Mr. Carpenter, said no. He said that Baldwin basically is instructing the armorer how to do their job to hurry up and give it to me fast. That is the moment that Mr. Carpenter says you need to stop and say, no, I'm not going to hurry up. I'm going to slow down. This is creating an unsafe situation. Always on any kind of live training exercise, you don't want to put people in a nervous position. Telling someone to rush with firearms is not accepted. Now, the footage shows Baldwin lying on the floor, explaining to the crew how the next shot should go. The prosecutor said he's doing what we saw previously in one of the videos. He's using the weapon as a pointing stick. They responded, when Mr. Baldwin behaves this way, that is the responsibility of the part of Miss Gutierrez. To intercede in correct and unsafe behavior, the expert said, and he would start pulling him aside and saying, let's be careful with that muzzle. Now, the clip also showed the moments after the director yelled cut. Baldwin let loose another blank round. Now, Carpenter said that when somebody yells cut, nothing else should be fired. He said he went off script and fired for whatever reason he felt he needed to fire. Carpenter said, I would have said something to him afterwards. I would have asked him why he did it. Was there something wrong with the firearm? Why did you let that extra round go off at the end? Now, Baldwin could have used a Nerf gun in the scene, Mr. Carpenter said, when he accidentally shot Hutchinson. Asked if there was no need to use a weapon in the scene, which was a rehearsal known as blocking, Carpenter said absolutely. He said there's absolutely no need for it unless the actor specifically requested the prop. And you can, in blocking scenes, use a Nerf gun or your finger. It's to make sure everything is in the right spot it's supposed to be in. Carpenter said that Baldwin insisting on using a weapon was a bit outside of the norm. The trial continues, but we get a little preview of more information that wasn't known to us yet. So, if you want to catch the trial, we have them all.